Welcome back to the Law Stash channel. My name is Anton Vieltsin and I'm a criminal defense attorney here in the Southern District of California. In many of my videos, I finish by telling you that the evidence seized as a result of a violation of the Fourth Amendment should be suppressed from criminal proceedings. It means that it cannot be used against the defendant in criminal trial and other proceedings. The idea is called Exclusionary Rule. In one of my videos, a viewer suggested that I should discuss the Supreme Court case Mapp versus Ohio. It is a significant case dealing with exclusionary rule. So that's what we're going to do today. We're going to discuss the history behind the exclusionary rule and specifically Mapp versus Ohio and how the rule applies to the states and the federal government. So let's go ahead and let's discuss Mapp versus Ohio. In this video, we're discussing a 1961 Supreme Court case, Mapp versus Ohio. And before we discuss the exclusionary rule, let me explain how I'm going to approach this case. First, I'm going to discuss the history behind the exclusionary rule. Then we're going to talk about the facts. And then finally, it's going to be the law that comes out of Mapp versus Ohio. So here's something that we need to always remember. The Fourth Amendment protects you against unreasonable searches and seizures, meaning that the officers, generally speaking, need to have a warrant before they can search or seize items from your home and other places that are protected by the Fourth Amendment. Until 1914, if the police seized property from you illegally in violation of the Fourth Amendment without a warrant, you could recover that property and seek civil damages. Get the state to pay for the fact that they took your property. But that evidence could be used against you in the court of law. Weeks versus United States, a 1914 case, said that evidence obtained by the federal law enforcement in violation of the Fourth Amendment could not be used against you in the criminal proceedings. This is really the birth of exclusionary rule. After that, we have states who are adopting this rule. 17 adopted, 30 rejected the rule. Now, something to remember, the case Weeks only applied to the federal government. So it is if the FBI or other federal agency searches, seizes your property, and you're then charged in the federal court, that evidence cannot be used against you. But in the state court, the idea was different. Which brings us to Mapp versus Ohio, a 1961 case.
I had to get out of that other control room. That weird guy kept running in and out of there. But we'll be right back, right after these commercial messages.
If you'd like to purchase one of these t-shirts, go to my website, lawstash.com/merch. Thanks for watching. So here's what happened in Mapp versus Ohio. This is a case that initially deals with illegal betting. We get an anonymous tip that Virgil Autry will be at Holly Mapp's house along with illegal betting slips and equipment for numbers game. Virgil is wanted for questioning in connection of a bombing of a rival gambling racketeer. Fun fact, it is the future boxing promoter Don King that we're dealing with. Two officers arrive to Mapp's house. It is a two-family residence. They knock on the door and they seek entry into the home. However, Mapp calls her lawyer, who tells her not to let the police in without a warrant. Remember, you don't have to consent to a search of your home. So that's exactly what she does. She tells him to go away, and she does not consent to the search. So the two officers leave the premises, and 3 hours later, they come back with more officers. This time, they force the door open, enter the home. Mapp demands to see a warrant. They show her some piece of paper which people believed was a warrant. She then puts it in her dress. There is some struggle ensues. The officers retrieve the piece of paper, quote unquote warrant, and we never see that piece of paper again. And it is not even introduced as evidence in the criminal proceedings. Here's the evidence that was seized from Mapp's home. It is the betting slips and the pornographic books and pictures. Now, by the way, Virgil is cleared from the bombing. We're dealing with Mapp, who is being prosecuted. And she gets prosecuted for possession of pornographic books and pictures, which is a misdemeanor in Cleveland. Now, we get to the Supreme Court, but before we get there, Mapp argues at all lower levels that she cannot be prosecuted for possessing pornographic material because, after all, that evidence was seized illegally. The officers did not have a warrant to enter the home and seize that property. Here's when we get to the Supreme Court. The states argue that they don't have to comply with the exclusionary rule. After all, there are other remedies that Mapp can use. She can recover her property. She can also sue the state, but they can still use it against her in the court of law. And this is what I just said. The pre-existing remedies exist, but the Supreme Court says that these are worthless and futile remedies, because after all, she's still being prosecuted.
Hello, Mr. Adjuster. When you gonna pay my claim? I sent you the form weeks ago.
Oh, I'm sorry, Mr. Leahy, but your claim hasn't been completely processed yet.
Without the exclusionary rule, the Fourth Amendment protection would be merely a form of words. It means nothing without the protection. And it would also be valueless. The Fourth Amendment and the 14th Amendment not only logical dictate of prior cases, but it also makes sense. Why did I bring the 14th Amendment here? The Supreme Court says that the Fourth Amendment and its protections can be used by citizens in state court through the 14th Amendment, which applies to the state courts and state proceedings. And finally, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold, meaning that the Supreme Court tells the state court that the exclusionary rule applies to them, and that citizens of the United States, whether they're being sued in the federal court or in the state court, have to exclude the evidence against them that is found illegally in violation of the Fourth Amendment. So from now on, anytime you watch any of my videos where the police violates the Fourth Amendment, enters the home without a warrant, searches an automobile without an exception to the warrant, the evidence must be suppressed, meaning that it cannot be used against the defendant in court. And so from now on, I will always link this video in all of my future videos. Hopefully you now understand how the exclusionary rule applies to state and federal court. And there's a related concept called fruits of the poisonous tree doctrine. Any evidence that is derived after the illegal search all has to be suppressed. So it is kind of a chain that we're looking at. The second there's an illegal search, everything after has to be suppressed. It doesn't always mean that the case will be dismissed against you, because it is the evidence that's being suppressed. If there's other evidence found against you without a violation of the Fourth Amendment, and it is found independent of any violations, that evidence can still be used against you. Hopefully you understand how exclusionary rule works. You understand Mapp versus Ohio. If you liked this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you'd like to purchase one of these t-shirts, go to my website, lostash.com/merch. Thanks for watching.